Hey there, everyone. I'm Jeff Dadarian, News 8 investigative reporter. I'm here in our digital studio here at News 8, and we're going to talk about a story that's airing tonight at 6 o'clock with Dennis House and Ann Nyberg on News 8. It has to do with the so-called Connecticut cannibal. I'm sure you've heard about this story. This is a person who was found not guilty by reason of insanity, was sentenced to 60 years, served about 10 years or so, and is now going through the release process. Tonight at 6, we'll talk to the family. We'll also talk to an author from Milwaukee that was connected to the Jeffrey Dahmer case. You probably remember that case. 17 people were killed, their body parts chopped up, put into a refrigerator. Dahmer was arrested for that and obviously convicted of it, and he was killed in prison. But that'll be tonight at 6. But before we get to that, we're going to talk with attorney Ryan McGuigan, who is a former state prosecutor here in Connecticut, just about the process in terms of how does it work for somebody who's convicted of this, well, actually not convicted, found not guilty by reason of insanity, is in a psychiatric hospital, and then it goes through the steps of getting released, because a lot of people are talking about this in Connecticut. And so I want to bring Ryan on now and just say hello. Ryan, thanks for being here. We appreciate it, first of all.
Thank you very much for having me.
Yeah, absolutely. So this case obviously is getting a lot of attention because of the nature of it. It's gruesome. It's horrific. But can you just talk about first from a legal point of view, what happens when someone is found not guilty by reason of insanity? Why is that different than a regular, quote, guilty charge? If you can just kind of talk about that first.
Sure. Well, I'll take you through the whole process.
Okay.
Say that if you're a criminal defense attorney and you believe that your client has some sort of a mental health defect, and you also believe that that mental health defect rose to the level where your client would have been substantially incapacitated from understanding that their actions didn't conform with the law, and or they could not conform their actions with the law. And in a situation like that, you have 45 days from the time of the first pretrial, although that time period is ministerial. But you have a certain time period where you have to inform the judge that you intend to enter a plea of not guilty by reason of insanity, and then that begins a process in court of a review. And during that review, the judge will then have a hearing, and a psychiatrist or a psychologist will have to testify, and you'll have to prove by a preponderance of the evidence, and you as the defense attorney have to prove that your client lacked the capacity, substantially lacked the capacity to understand what their actions that their actions were against the law, and or they could not conform their actions with the law. The common law test for that would be the policeman at the arm test. Okay. And that kind of means this, and it's just sort of a common sense thing. If the person would have committed the same act with a policeman standing right next to them, then they're by definition insane. So when you do present that to a court of law, the psychiatrist will testify. The state can cross-examine the psychiatrist, although in many circumstances the lack of capacity is apparent, and normally sometimes you'll have the state agreeing with you that the person lacked the capacity, and the proper place for them would be in the Forensic Institute, not in a jail. But
so let me just stop you for 1 second,
Sure.
Ryan. So does the person have to understand what they're doing is wrong, or like, in other words, do they have to have frame of mind? Do they have to have some intent? Do they have to have some state of mind where they know what they're doing is wrong?
Well, they didn't. They did know what they were doing. They just didn't know that what they were doing was against the law.
Okay.
And or if they did, they couldn't control themselves. So if they had some sort of a Tourette response,
okay,
where they would say, "Yeah, I knew that what I was doing was wrong, but I couldn't stop myself from doing it."
Okay.
That's sort of that second one. And the first one is I had no idea what I was doing was against the law.
Okay.
So in those two circumstances, you don't think that we come to the understanding that the person did not have criminal intent.
Okay.
They intended to do the act, but they didn't have criminal intent because they didn't understand that it was against the law, or they did understand it was against the law and they could not stop themselves from doing it. Under those circumstances, the person would be found not guilty by reason of insanity.
A little bit of a slippery slope, though, right, from a legal point of view? Because isn't there's some wiggle room, and defendants maybe try and use that and say, like, well, I didn't know it was against the law. I mean, do these cases that's why these cases are tricky, right?
They are tricky. However, psychologists and psychiatrists are very good at figuring out whether somebody's being mendacious or somebody's just making it up. So in those circumstances, that's why we have a hearing before a judge, and the judge will make the determination by a preponderance of the evidence, which means it's more likely than not. Normally, at least in this state historically, there have not been many pleas of not guilty by reason of insanity, and the reason is that a lot of criminal defense attorneys don't like that defense, because it suddenly takes the punishment or the time period that a person might be incarcerated away or out of the control of the lawyers and the judges and the prosecutors, and it puts it into this sort of nebulous place where the psychiatrists and the psychologists at Whiting Institute determine every second year whether the person has been restored to sanity. And because of that, what the belief is with the criminal bar anyways, is that a lot of times you will have people spending more time at the Forensic Institute for the activity than they would if they had just pled guilty and said, yeah, mea culpa, I did it and I meant to do it.
But not in this case, though. In this case, he
got a lot less.
Yeah, so he got, just for everybody who's maybe just joining us, we're talking with attorney Ryan McGuigan, who's a former state prosecutor. He's now an attorney here in Connecticut, obviously still practicing. We're talking about this Connecticut cannibal case. I have a story tonight at 6 o'clock on News 8 that's basically going to take a deeper look at the case. We talk with the family, with the victim's family. We'll report some new information about what happened that night. We also will talk with an author from Milwaukee. She was a Cub reporter at the time when the Jeffrey Dahmer case happened, and we talked to her about basically this propensity to kind of do this again. That's kind of the big question on everybody's mind, and Ryan was nice enough to come in here to the digital studio, Ryan McGuigan, to talk with us today, just sort of an expanded conversation here online at WTNH.com, because this case has a lot of people talking. But back to my point, Ryan, so basically the person Smith was, who was found not guilty by reason of insanity, sentenced to 60 years, only served about 10 years of that, and has now sort of gone through this step-down process, which has allowed him to not really serve, in the family's eyes, a lot of time. So, but this is how the system is set up, right? For people who are watching and listening, like scratching their head saying, how can this be? It can be because this is the way things are set up, and this is how the system works, right?
Well, the system is that once the psychiatrist has established that the person was substantially incapacitated, and the judge finds that the person, by a preponderance of the evidence, is not guilty by reason of insanity, now they're actually referred to as an acquittee because they've been acquitted of the criminal conduct.
Okay.
The next step is whether or not the judge determines that they need. Well, strike that. The judge will commit the person to the Psychiatric Security Review Board. And then that board determines whether or not the acquittee, not a defendant anymore, it's an acquittee, the acquittee needs to be committed,
okay,
or whether they can have supervised released, or whether they should just be discharged. And that Psychiatric Security Review Board now has control over that acquittee.
Okay.
And the maximum that they can hold them by law is the maximum of the crime itself. So in this particular case, it was murder, so the maximum is 60 years. So the maximum that the Psychiatric Security Review Board can hold somebody in that circumstance is those 60 years, and then they can't hold them any longer.
Okay.
But however, they can hold them at up to any time that they've determined that the person no longer needs to be supervised by them. And that review happens every 2 years.
Okay.
And in this particular case, after another 2 years went by, they determined at some point that this acquittee should be released on supervised release, and I don't think we knew about that. I think that is just sort of
Yeah.
quiet or it's not public information. So what we didn't know in the public is that person had been released to the public for a long time, could be 6 months, could be even longer, and had conformed their behavior to the letter of the law, and no longer essentially was an issue or a danger to the rest of us.
I think the rub here too is that he's going to have to follow some certain conditions. The family's worried that he might not take his medication. The family says tonight, and again, our story will air tonight at 6 o'clock on News 8, that basically the family speaking, their words, not mine, he said all the right things, he knew what to say, he's conforming, they let him out a little bit, he was good, which, we have to just go on face value, and the Psychiatric Review Board has determined that he's fine to be, to take this next step of the release process. But is there any remedy to change this? Is there any legal remedy, that if the family wanted to say, we don't agree with this decision, we don't like it, we want to change it? Is there anything now, or does the Psychiatric Review Board, Ryan, just basically, they have the authority now to kind of make this a reality?
It is a reality, and their decision is what the decision is.
Okay.
So there isn't any appellate review of this. Once the person has been committed so what happens, like in regular criminal cases, just to give you the lay of the land.
Yep.
In a regular criminal case, you're prosecuted by the executive branch. You then go to the judicial branch, and then they'll determine whether or not you're guilty or you're not guilty, and you have a trial or you don't. When you've been found guilty or you plead guilty, the judge will then sentence you, and the judge can sentence you to jail, or they can sentence you to probation. If they sentence you to probation, the judge is now sort of in charge of you, because probation goes through the judiciary. If they sentence you to jail, the judge will say, I commit you to the Commissioner of Corrections.
Okay.
So the Commissioner of Corrections in the executive branch now has control over the body or the habeas of the person himself, of the defendant himself. In this case, rather than the judge saying, I commit you to the Commissioner of Corrections, what they say now is, I commit you to the Psychiatric Review Board for their determination of what they should do with you. And under both those situations, once the judge has committed somebody to either corrections or to the Psychiatric Review Board, those boards and the Commissioner of Corrections now has authority of what to do with you. Okay. So if the Commissioner of Corrections wants to release you after 4 days, they can do that. Okay. They have the authority to do that. So in this situation, there's nothing that can be done.
Okay. And so what about when this Tyree Smith goes to get a job or goes to apply for an apartment somewhere? What happens when someone pulls up his record now? Does it say, what does it say? Does the crime appear there? Does it, what exactly do we see, or what exactly would someone see, and what's his official status? Is he not guilty and it never happened, or what's the footnote?
Again, so like we talked about before, they're known as, once the judge determines that the person is not guilty by reason of insanity to the Psychiatric Review Board, you are known as an acquittee. You've been acquitted of the criminal conduct.
Meaning that it goes away.
It means that it's
acquitted is a big word, right?
There. Yes, that's correct.
It's a big word.
Yes, and I would believe that with our erasure statute, that any of the information prior to that would be erased from their record as well.
So, in other words, and I don't mean to beat a dead horse here, but so he applies for a job, somebody does a background check, and they pull up his background check, 0 will show up there in terms of this crime, this murder that happened.
Well, yes, I mean, arguably, but the internet has a long history, so it'd be difficult if somebody were to do a background check, not to find this particular story online.
Right. That's very, very true. Good point. What do you think the Psychiatric Review Board, and I know you're not part of that and knowing what they were thinking, but these cases in general, they seem to be, they're first of all very controversial. The victims' families probably are never happy, understandably, but there's this process, or there's this thought that we're trying to return someone back to society. That, in other words, the judicial system has determined that, hey, he didn't know what he was doing at the time. He didn't commit this crime under his own free will, if you will, and we need to return people to society. So this Psychiatric Review Board in Connecticut, let's just chat about it for a minute. I'd just like to get your thoughts. It seems like it's a difficult board. It's a difficult job to be in, right? Because you're making decisions for people who have done these heinous things, but by the same token, their mission, and I'll stop talking, let you talk, but their mission is to rehabilitate people, and that's what they're arguing in this case.
Their only mission is to rehabilitate.
Okay, only. Good point.
That's what their point is.
Okay.
So in the criminal justice system, we have 4 reasons to punish people, and one of them is rehabilitation. There's also retribution, which is you've done really bad, and we want to punish you for this.
Yep.
And then there's incapacitation, which is you're a really bad person. We can't have you in general society. And therefore, we're going to have to take you out of society and have to put you in a place.
Right.
So the Psychiatric Review Board only deals with rehabilitation. They don't care about punishing you. They don't care about deterrence, which is another reason about sending a message. Because again, this is a person that didn't understand. That's what they've already determined. The judges found that they didn't understand what they were doing at the time, or they couldn't control themselves from doing what they were doing at the time. So there's no amount of punishment that would deter that person from doing that.
Right.
There isn't any amount of punishment that will get them to say, geez, I'm really sorry for what I did because I didn't understand it in the first place.
Okay.
So any of the other reasons for criminal punishment are not there. So the only thing left is rehabilitation. So when you at the Whiting at the Forensic Institute, the only thing that they do is rehabilitate people, because that's the whole point of being a mental health institute is to get people better. Okay. It's a hospital. You're there to rehabilitate yourself. So that's the only thing that they're concerned with. And once that person has established that they have been rehabilitated and they can return to society, at that point, the board itself has no other choice but to release the person, because you can't just keep them there indefinitely in the guise of punishing them, because this is not the place that you go to get punished. That's jail.
Right. Well, this is the place where you go to get better.
You go to get better.
Get better. Okay. Last question, and we're with Attorney Ryan McGuigan. He's an attorney here in Connecticut, a former state prosecutor. We're talking about this Connecticut cannibal case. Again, News 8 investigates. I have a story that's going to air tonight at 6 o'clock where we talk with the victim's family. The person who was responsible for this is now getting released, and we're talking about that today in a more expanded way with Ryan. So one last question, Ryan. So if the person that committed this crime, if they go out and commit another crime, or they don't follow the rules, they cut off the ankle bracelet, they rob a bank, whatever they do, does this crime come back and they say, hey, you know what? You've got to now start serving time for the time we let you out, or does this go away forever, even if he does something wrong again?
If he does something wrong again, he'll be criminally charged with the new offense. Yep. But my belief is once he is released, that there's no sort of violation of the probation, as long as he's not on conditional release anymore.
Because that would be, and again, I'm not trying to play lawyer here, I don't know what you know, but that would sort of be like a double jeopardy, right? You can't, if he's free from that crime, or free from the incident, the killing, whatever, however we want to say it, once he's free from that and he's considered released and he's found not guilty by reason of insanity, and they've released him, the psychiatric, then you can't, it would almost be double jeopardy, I would think. I don't know, you obviously would know better.
That's the wrong terminology.
Okay.
Double jeopardy, because the person has been acquitted of that original crime. So yes, so you're not really asking, what can they be retried for it?
Okay.
Because the answer is no, they cannot be retried for it. The only thing that can happen is if they're still on some sort of conditional release and they violated any of the conditions, then you could be brought back to Whiting under those circumstances. But you wouldn't really need to do that, because if he goes out and he commits another crime, he would have to establish all over again that at the time that he committed that crime, that he had a mental defect and he was substantially impacted by that and his ability to control himself.
Okay, understood. Ryan McGuigan, attorney here in Connecticut. Thanks for being with us here for this digital extra here on WTNH.com. Again, you can watch the story tonight at 6 o'clock on News 8. We're going to take a look at this cannibal killing here that happened. We talk with the family. Again, I talk with an author who covered the Jeffrey Dahmer case as a rookie reporter in Milwaukee. She'll give her thoughts. We'll also hear from the Psychiatric Review Board in terms of what are they saying in terms of why they decided to release this individual. So there's a lot of information in my story that's coming tonight. And also, remember, if you can, follow me on Instagram, Jeff Dadarian TV. And if you have any story ideas or story tips, I would love for you to send them my way. Also, you can search me on Facebook as well, Jeff Dadarian on Facebook. And any story ideas, confidential, I always love to hear from people because I get a lot of good stories from people. So attorney Ryan McGuigan from here in Connecticut joining us today on WTNH.com. Look for the story tonight, 6 o'clock, News 8. And thanks for being with us, and have a good rest of your Thursday.